Alright family, today's topic for self-represented in family court is relocation in family court as pro se. This is another complex topic, so we want to explain why it is even more challenging as a self-represented litigant. These cases are some of the most challenging and emotionally charged situations you'll encounter. And since you're representing yourself or are pro se, that means you're navigating this complex legal issue on your own. It's not going to be easy at all. And you're facing an uphill battle. The stakes are high and the pressure can be overwhelming. Judges don't like to disrupt a child's life unless there's a darn good reason. They prioritize stability and continuity for the child. We're talking about the welfare of a child, which is the court's primary concern. Every decision made revolves around this central issue. And that's not something I take lightly. The court scrutinizes every detail to ensure the child's best interests are being served. So, if you're planning to move a significant distance away with your child, you need to be ready for a rigorous examination of your motives and plans. You better come prepared to prove it's in their best interest. I'm talking rock-solid evidence, a well-thought-out plan, and a clear demonstration of how this move benefits the child. And a calm, reasonable demeanor. The court will be looking for a rational, well-argued case that leaves no doubt about your intentions and the positive impact on your child's life. First things first, you've got to know the law in your state. This isn't just a suggestion, it's a necessity. Each state has its own unique set of rules and regulations that govern relocation, especially when it involves children. Ignorance of these laws can lead to serious consequences, so it's crucial to be well informed. Every state has its own rules about relocation, and you need to know them like the back of your hand. This means diving deep into family law books, consulting legal experts, and perhaps even attending workshops or seminars. The more you know, the better prepared you'll be. What's the burden of proof? This is a critical question. The burden of proof refers to the obligation to present evidence to support your claims. In relocation cases, you must demonstrate that the move is in the best interest of the child. This often involves providing detailed plans and justifications. What factors does the court consider? Courts look at various factors, including the child's relationship with both parents, the reasons for the move, and the potential impact on the child's well-being. Understanding these factors can help you build a stronger case. Don't go in there blind, because ignorance is not a defense in my courtroom. Preparation is key. Gather all necessary documents, consult with your lawyer, and be ready to present a compelling case. You need to be able to articulate why moving is not only good for you but more importantly, for your child. This means showing how the move will provide better opportunities, a safer environment, or improved quality of life. The court's primary concern is the child's best interest, so make sure your arguments reflect that. This is where you gotta convince the court that moving is in the best interest of the child. You need to present a compelling argument that clearly demonstrates how the move will positively impact the child's life in multiple ways. And I'm not talking about vague promises, I'm talking concrete evidence. You need to back up your claims with solid documentation and reliable data. The court wants to see facts, not just hopeful statements. Better educational opportunities, show me the school rankings, provide detailed information about the academic performance, extracurricular activities, and overall environment of the new school. Improved living conditions, show me the housing options, highlight the safety, space, and amenities of the new neighborhood. Compare it to the current living situation to show a clear improvement. Enhanced family support, prove it. Demonstrate how the move will bring the child closer to extended family members who can provide emotional and practical support. Employment stability, healthcare access, lay it all out there. Show the court that the move will provide a stable and supportive environment for the child, with access to essential services. Remember, it's not about what you want, it's about what's best for the child. Every piece of evidence should focus on how the move will benefit the child's overall well-being and future prospects. You're moving, but that doesn't mean you get to cut the other parent out of the picture. You need a solid visitation schedule that ensures the child still has a meaningful relationship with both parents. Who's paying for travel? How often will visits be? Be realistic, be fair, and be prepared to compromise. And remember, if the child is old enough and the law allows, their opinion matters too. Chapter 4. File the correct motion and serve proper notice. Paperwork, paperwork, paperwork. You gotta do it right, or you'll be back to square one. File the correct relocation petition with the court, and make sure the other parent gets proper notice. Don't try to pull a fast one. Be transparent, follow the rules, and meet those deadlines. This isn't a time for shortcuts. Chapter 5. Anticipate and counter the other parent's arguments. Put yourself in the other parent's shoes. They're probably not going to be thrilled about this move. They might say it'll disrupt the child's life, reduce their contact, or that you're just being vindictive. You need to be ready to address those concerns head-on with evidence and logic. Show the court you've thought this through and that you're putting the child first. Chapter 6. Gather strong evidence and witnesses. Don't just tell me, show me. Get those school rankings, housing costs, job offers, anything that supports your case. And don't forget about witnesses. Teachers, therapists, family friends, anyone who can speak to the child's best interests. A strong case needs strong evidence, so build it like a brick house. Chapter 7. Stay professional and avoid emotional arguments. This is court, not a soap opera. Leave the drama at the door. Stick to the facts, be respectful, and don't badmouth the other parent. The judge wants to see that you're focused on the child's well-being, not on settling old scores. Keep your cool and let the evidence speak for itself. The court might appoint a guardian ad litem or order a custody evaluation. This means someone will be looking into the situation and making recommendations to the judge. Cooperate fully, be honest, and show them that the move is in the child's best interest. Don't try to hide anything. Transparency is key. You're your own lawyer here, so you better be prepared. Organize your arguments, gather your documents, and practice. Use a case map to keep everything straight. Anticipate the other side's questions, and practice your answers. The more prepared you are, the more confident you'll be in court. Going to court should be a last resort. Mediation is often required, and it's a chance to work things out with the other parent without a judge's ruling. Be open to compromise, but don't be afraid to stand your ground on what's important for your child. You never know, you might be able to reach an agreement that works for everyone. Look, I've seen it all in my courtroom, and let me tell you, relocation cases are tough. But if you come in prepared, present your case logically, and always put the child's best interests first, you've got a fighting chance. Remember, this isn't about winning or losing, it's about doing what's right for your child. So do your homework, stay calm, and fight for what you believe in.